essentially now are only the fiscals. Ayan, the provincial state prosecutors, the national, regional state prosecutors, other officers as may be authorized by law. Take note that as of October 3, 2005, the MTCs can no longer conduct preliminary investigation. I mentioned that earlier in Rule 110. Now, what is the purpose for conducting a preliminary investigation? It is for the purpose of finding or determining the existence of probable cause. Okay. Take note that yung existence of probable cause, determination of the existence of probable cause for purposes of indictment is an executive function. Meaning it is performed now only by the fiscal, as provided for under the rules. But determination, there is on the other hand, another determination of probable cause. If the determination of probable cause is for purposes of issuance of a warrant of arrest, that is a purely judicial function. It cannot be performed. It's not the function of the prosecutor. That is why, as was mentioned by some justices, yung uso-uso ngayon there is, once the information is filed in court, they lose the information, they lose in the preliminary investigation, before they find the information, so make a preliminary investigation, and then the information is filed in court, so they lose there. They do not go up to the DOJ for purposes of review of the fiscal's or the prosecutor's determination of probable cause. What they do is motion for judicial determination of probable cause. Yan ginagawa na motion for judicial determination of probable cause. But you don't find that under the rules. Because their purpose there is to seek a reversal of the resolution of the fiscal. There is a motion for determination of probable cause. There can be a motion for determination of probable cause addressed to the court for purposes of issuance of a warrant of arrest, not for purposes of indictment. Because what the lawyers do now is if they cannot seek a reversal of the resolution of the investigating prosecutor, even if they went all the way up to the DOJ via petition for review, what they do is stop the court. Anyway, nasa yun na yung Mr. Court or Miss Court. Anyway, the information has already been filed before you. You determine probable cause. No! The court will determine probable cause, but only to issue a warrant of arrest. Not to determine probable cause for purposes of indictment. Kasi na-file na information, meaning that if the information is already been filed in court, the prosecutor is only the one authorized to determine probable cause. To find the information has already found probable cause. And the Supreme Court said that will not be disturbed by the court. Unless there is a finding of grave abuse of discretion. The court will not interfere with the fiscal's or the prosecutor's determination of probable cause. That is within their jurisdiction for purposes of determining probable cause. That is why, if an information has been filed in court, after the there is already a filing of the complaint with the fiscal's office, the fiscal resolved the case, and recommended the filing of the information in court. The recommendation is approved by the city prosecutor or the provincial prosecutor, nasa court na. Please take note, hanggang doon ang authority ng prosecutor. Once an information is filed in court, the authority of the prosecutor ends there. Meaning that once the information is filed in court, it is already the court that will call the shots on what to do with the case. It is only the court that is why once the information is filed in court, the fiscal can only file motions. The fiscal cannot say that, we made a mistake, Your Honor, please, I'm withdrawing the information, whether you like it or not. No way! They cannot do that. Because you have already submitted to the jurisdiction of the court. Tingnan mo na information. It is not the court who is the bida. Before the filing of the information, you may still be the bida. But once the information is filed in court, it is already the court who will call the shots with respect to any disposition with respect to the case. And there's the case of, Crespo versus Mogul, 1987, and then repeatedly, until yung Paul Roberts et al. Versus CA et al. Sabi ng Supreme Court, once the information is filed in court, wala na kayong pakialam. they can still file a petition for review of the resolution of the investigating prosecutor. They filed that before the DOJ. Okay? Now, they filed it before the DOJ. Under the present rules, once a petition for review is filed before the DOJ, after the information is filed in court already, they can only file a motion for suspension of the proceedings in view of the pendency of a petition for review before the DOJ. And they have to do that before arraignment. Okay, so, because under the present rules, what could be the ground for suspension? Additional ground for suspension of the proceedings, suspension of the arraignment, in view of the pendency of a petition for review before the DOJ. But likewise, under the present rules, bago kasi yan, under the present rules, once the petition for review is filed, okay, suspended. But the suspension of the proceedings before the DOJ, and before the court, suspension of the arraignment, would only last for 60 days. Record from when? From the date of the filing of the petition for review. That is why ako, once a motion to suspend proceedings and the ground to file the petition for review before the DOJ, I always ask for the original, for a copy, yung stamp received by the DOJ, because the running of the 60-day period for purposes of suspension on that ground, yung filing of a petition for review before the DOJ, it starts to run upon the filing of the petition for review before the DOJ. That is one of the grounds now for suspension of the arraignment and further proceedings. Filing for petition for review either before the office of the either before the DOJ or the office of the President. That's the new rule now. Okay, so once an information is filed in court, let me go back to that, and I'm stressing it because it's very important. Wala nang pakialam ang fiscal. They cannot do anything with the case at their whim, at their pleasure, at their caprice. It is already the court that is the bida that calls the shots. Kaya nga, even if they secure a reversal, the information is filed in court na, okay, even if the accused, for example, secures a reversal in the DOJ of the resolution of the investigating prosecutor, it does not follow that the case which is already pending in court will be dismissed, will be automatically dismissed. So, they secure a reversal of the resolution of the investigating prosecutor, the DOJ, the Secretary Gonzales says, we are reversing the resolution of the investigating prosecutor, and I'm directing the investigating prosecutor or the trial prosecutor before that court to file the necessary information or to take the appropriate action. Yung appropriate action is only the motion to withdraw the information. Motion pa rin yan, Since it is a motion, it is subject to approval, granting, or denial by the court. So it does not follow that even if you seek a reversal of the resolution of the investigating prosecutor before the DOJ secretary cannot order the court. So say, hey Mr. Court, hey Miss Court, you better dismiss this. Kasi, ano na kami we have come to the conclusion that we have already reversed resolution of our investigating prosecutor. No, because the information has already been filed in court, magpe-prayer na lang kayo. Motion to withdraw information or motion to dismiss the case because of a reversal of the resolution of the investigating prosecutor. And therefore, the court, which calls the shots because the information has already been filed in court, the court can either, the authority in court na, to grant or deny the motion. I'm very particular with this because nadali ko dito There's a resolution. Information was filed in court before me. They moved to this, suspend proceedings. They were able to secure a resolution reversing the information, reversing the resolution of the investigating prosecutor, and ordering the investigator to file a motion to withdraw. Naturally, not sa akin na information, following the doctrines laid down in Crespo versus Morgan, et al. So what did I do? I denied because I found very long possibility that there is a case. So I denied it. Motion for reconsideration, I not denied. They brought up my resolution on certiorari to the Court of Appeals. Not only that, they filed an administrative case against me. Super bobo daw ako, gross ignorance of the law. Super off. Okay, so I was, that was eventually, that was eventually dismissed. That was eventually dismissed. Even the certiorari was dismissed. But the point is, I was sustained, no? On all counts, no? I was even brought to the ombudsman. Huh? Okay, but all this was dismissed because they saw, I had jurisprudential backing. Cornejo versus Mughal and a whole lot of cases that will back up the view of the court that I can resolve it either way because I am already the bida. So that is what I'm telling you, no? Once the information is filed in court, the court already calls the shots. Okay. Now, this is with respect, let's say, to preliminary investigations conducted in two ways. Yung regular PI, which is under Section 3 of Rule 112, and the inquest proceedings under Section 7 of Rule 112. We're talking about yung take note the procedure in Rule 112 for purposes of preliminary investigation is adopted with respect to a complaint filed before the fiscal's office for purposes of a preliminary investigation without any arrest. Wala lang. Yung ganyan ka lang ang unjust fixation. You go file. No arrest. Okay? Cute mo. Unjust fixation. Okay. Now, if however, there is already an arrest. So, it is, you go to the procedure applied in Section 7. Ito yung inquest proceedings. Now, sa Section 3, so walang arrest, you go file it before the fiscal's office, then the fiscal will give opportunity to the respondent to file counter affidavit as well as any controverting evidence. There's a need for clarificatory questioning. The fiscal can propound the questions. The counsels cannot participate in the clarificatory questioning. If they would want to propound questions, they would want to propound, because this is not a judicial proceeding, take note. If you would want to propound questions or preliminary investigation, you have to furnish your question. You have to furnish the fiscal with the questions. And it is the fiscal who will propound the questions. Okay, it is the fiscal. Okay, so after that, the fiscal is already clear. Because a clarificatory hearing will not be conducted if the fiscal is clear. On the documents presented in the course of the preliminary investigation. Now, if the fiscal now submitted for resolution, if the fiscal finds probable cause, recommend filing the information, the accused now will file an MR, denied, go up to the information filed in court, go up to the DOJ. Yun na yun. The DOJ now will evaluate. Now, once the DOJ says the resolution is correct, and therefore, i-direct niya to move for continuation of the proceedings. Lifting of the suspension, continuation of the proceedings. Kasi na-sustain. But if there's a reversal, the DOJ can likewise order to move to withdraw the information. And it's still a motion. Take note, it's still a motion. You know what a motion is. It is a written application for reliefs. So you apply to the court already. It's not an order from the DOJ. Okay. Now, if however, on the other hand, if a person has been lawfully arrested without a warrant of arrest, the procedure that will be applied will be under Section 7 of Rule 112. Take note Section 7 of Rule 112 applies to cases only of lawful warrantless arrest. Meaning, accused has been lawfully arrested without a warrant of arrest. Because basically, what would validate an arrest is if it is effected by virtue of a valid warrant of arrest. Without a warrant of arrest, you cannot arrest. Okay, now, cases of lawful warrantless arrest. Okay, please. This is the procedure that is adopted. Therefore, itong Section 7 children's, Section 7 of Rule 112, i-relate nyo with Section 5 of Rule 113. Di ba? Because under Section 5 of Rule 113, these are the circumstances that would make the arrest lawful. Warrantless arrest. A first officer may without a warrant of arrest, without a warrant, arrest the person. So these are the circumstances authorizing a lawful warrantless arrest. You know this. 1, flagrante and delicto rule. 2, hot pursuit rule. 3, if the accused has escaped from the penal establishment. Meaning that, if under these circumstances, if there is no warrant of arrest, even if there is no warrant of arrest, but it falls under any of the circumstances, and then under any of the circumstances, even if there is no warrant of arrest in this law. Okay. Flagrante delicto rule. You know this, huh? Sabi, when in his presence, the person to be arrested has committed, is actually committing, or is attempting to commit an offense. Let me just point out to you, wala problema, flagrante delicto. Has committed, is actually committing, or is attempting. Di ba before, because I hear in radio, yung mga police, they say, or some lawyers, about to commit an offense, ina-apply yung flagrante delicto rule, has committed in the presence of the police officer, has committed, is actually committing, or is about to commit. Hindi na yung about to commit, it is now attempting to commit. Properly so. Kasi di ba, pagka about to commit, you're simply acting on suspicion. When you say attempting to commit, attempted station of offense, there is already an overt act of the crime intended to be committed. You look at this this way, attempting to commit a crime. Attempting to commit a crime. Okay, so kasi meron attempted station of felony under Article 6, the revised penal code, there is already an overt act of the crime intended to be committed. Pero pag sinabi mo, is about to commit a crime, kaya ina-arrest ako, tapos pa rin ako yan eh. Bakit? Hindi pa naman tayo mo. What did make thinking, mama? So, about to. If you're arresting somebody without a warrant of arrest, only on the ground that he is about to. Ay, isip mo lang yan. That is only based on suspicion. Remember, suspicion. No matter how strong, no matter how contrived, can never amount to evidentiary proof. So it is now attempting to. Okay, now, ito, inamen dito, a hot pursuit rule. Okay, dito. When a crime or an offense has just been committed and he has probable cause to believe, based on his personal knowledge of facts or circumstances, indicating the person the arrest has committed it. Anong amendment dito? Di ba, before the revision of the rules, when a crime has just been committed and the arresting officer has personal knowledge of facts indicating that the person to be arrested has committed it. Tingnan niyo dito ngayon. He has probable cause to believe based on his personal knowledge of facts indicating that the person to be arrested has committed a crime. Kasi yung una, stringent eh. How can you expect the arresting officer? A crime has just been committed. Okay? Wala siya doon sa scene. How can you expect him to have personal knowledge? For it to effect a lawful warrantless arrest. Sometimes, i-report pa lang. Tayo na yung tao. I-report pa lang. They come. 10 hours after. Excuse me, walang pulis dito. Okay, so late na. How can you expect it? They were not there. Right back at the scene of the crime. So, binago. He has probable cause to believe based on his personal knowledge of facts, indicating that the crime has been committed and the accused, the person to be arrested, has committed it. Meaning that, the police officer, after the commission of the crime, he has been informed and reports on that, he goes to the crime scene. He conducts an ocular inspection of the crime scene. He interviews witnesses, and all the witnesses point to this person as the person who committed the crime. Don't even have personal knowledge because he was informed. Tapos he finds articles there that purportedly belong to that person who ran away after the commission of the crime. So, he has personal knowledge of facts indicating, he has probable cause to believe based on his personal knowledge. Alam niyo naman, pagka probable cause, facts and circumstances that would render a reasonable man to believe that the crime has been committed and the person, the respondent, is probably guilty thereof. So, hindi na kailangan yung personal knowledge. You have probable cause based on personal knowledge. But after the circumstances surrounding the crime, not necessary for purposes of a lawful warrantless arrest. Okay, now, the third situation for lawful warrantless arrest is if he has escaped from the penal establishment. No problem with that. Now, once a person has been lawfully arrested without a warrant of arrest under any of the circumstances provided for in Section 5 of Rule 113, go back, children, to Section 7 of Rule 112. Ito na yung procedure. To be adopted once a person has been lawfully arrested without a warrant of arrest under any of the circumstances provided for in Section 7 of Section 5 of Rule 113. Okay, so he's arrested. He is now brought to the inquest fiscal. He is now brought to the inquest fiscal. On the basis of the affidavits of the complainant and other witnesses, without conducting a preliminary investigation, the information may be filed in court. Why? Kasi may probable cause na-arrest ko siya lawfully without a warrant of arrest. So no need to conduct preliminary investigation. File the information in court on the basis of the affidavit of the complaint. Now, second step, before the filing of the information in court, the person who has been lawfully arrested without a warrant of arrest may ask for a PI, correct? That is the second step. Before the filing of the information, he may ask for a PI. Okay? Before the filing of the information. Okay. But he will be granted his request for a preliminary investigation. He will be granted provided he signs a waiver of the provisions of Article 125 of the Revised Penal Code. Alam naman ninyo yung Article 125 of the Revised Penal Code. That is what? That is not arbitrary detention. Take note, ito sa akin yung criminal law. That is delay in the delivery of detained prisoners to the proper judicial authorities. Take note, specifically, yung 125 na yan, it applies likewise to inquest cases. Only in situations where a person has been lawfully arrested without a warrant of arrest. Okay, before the filing of the information, he has been lawfully arrested without a warrant of arrest, he can ask for a PI, granted, for as long as you sign a waiver of the provisions of Article 125 of the Revised Penal Code. Alam niyo naman, under Article 125 of the Revised Penal Code, titled, Delay in the Delivery of Detained Prisoners to the Proper Judicial Authorities. What would constitute the delivery of the detained prisoners to the proper judicial authorities? Is it the fact that the person lawfully arrested without a warrant of arrest under any of the circumstances provided for in Section 5 of Rule 113? Is it the fact that that person is brought to the fiscal, Mr. Inquest Fiscal, eto, lawfully arrested ito without a warrant of arrest? Within 12, 18, 36 hours, as the case may be. Di ba yun ang limit? 12 hours for life penalties, 18 hours for correctional, and 36 hours for afflicted. Okay, what will the delivery consist of the fact that he is physically brought before the inquest fiscal and he is being identified as a person who has been lawfully arrested without a warrant of arrest? No! The delivery consists of what? The delivery of the detained prisoner to the proper judicial authorities is the filing of the information in court. Ito sabi in your criminal law. The delivery of detained prisoners to the proper judicial authorities consists in the filing of the information in court. Now, kailangan, he's often arrested, the information has to be filed within a period of 12, 18, 36 hours as the case may be. Now, he is asking for a PI. He is asking for a PI. Therefore, he has to sign a waiver. Kasi nakakulong pa siya, di ba? He's asking for a PI. He's detained. Okay, why would he have to sign a waiver of what Article 125, of the provisions of Article 125? Kasi ang requirement dyan, 12, 18, 36 hours, the information will have to be filed in court. And the preliminary investigation, once granted, in cases of inquest, it has to be completed in 15 days. O di lang basta-basta na sa 12, 18, 36 hours. And therefore, may stop yung counting. Because it has to be, you have to sign a waiver of the provisions of Article 125. Okay. Next step. Third step. If an information has already been filed in court, against this person who has been lawfully arrested without a warrant of arrest. An information has already been filed in court. The question is, can he still ask for a preliminary investigation, even if the information has already been filed in court against him? Yes. But he has to ask for a preliminary investigation within a period of 5 days. Record from the time he learns the filing of the information. Sabi the rules, the 5-day period within which to ask for a PI with respect to where an information has already been filed in court against the person who has been lawfully arrested without a warrant of arrest, that is mandatory. You have to comply strictly with the 5-day period. But this is procedural, di ba? Okay, because sometimes, ang sabi ng tao, the lawyer comes 15 days, 20 days, 30 days after the filing of the information. And the lawyer now asks for a preliminary investigation. Because my client has not been afforded the benefit of the preliminary investigation, he was simply arrested, Your Honor, and the information was directly filed in court. Okay, i-invoke mo yan. What will the court do? But your client has been informed already that the information has already been filed in court as early as a month ago. And under the rules, from that time, he can ask for a PI within a period of 5 days from the time he learns the filing of the information. So what will the court do? What do you think? What will the court do under those circumstances? Pag nag-invoke pa naman yan, in the highest interest of justice, Your Honor, you cannot expect this poor fellow, who is untrained in the complexities of the law, to ask immediately to comply with the law. Oh, what will you say? Nothing! Diba? Procedural. Interest of substantial justice. But strictly, yan ang rule. If the information is already filed in court, you are lawfully arrested without a warrant of arrest, you may still ask for a PI. But you have to do it under the rules, within a period of 5 days, reckoned from the time you learned the filing of the information. Okay, now, if a preliminary investigation has been conducted, there will be a record. If necessary, there's a record of the preliminary investigation. Correct? Take note that the record of the preliminary investigation, it does not form part of the records of the court with respect to that case. The records of the preliminary investigation do not form part of the court expediente. They are not considered part. They may only be made. Made as references. In other words, for example, the information has already been filed in court. The court would want to. The court is on the obligation to evaluate. To evaluate the entire records in the fiscal's office and find out as basis for the determination of probable cause to issue a warrant of arrest. Kasi information is already filed in court, meaning that the fiscal has already determined probable cause to indict. Now, the information is filed in court. The court now has the obligation now to determine naman whether or not to issue a warrant of arrest. And under the rules, take note that the RTC may look at all the records. The RTC may look at all the records of the proceedings before the fiscal in the course of the preliminary investigation to aid the court in determining the existence of probable cause for purposes of issuance of a warrant of arrest. The RTC need not propound questions to the complainant, to all those. Magre-rely siya sa records, but it must be the totality of the records. Sabi ng Supreme Court, it must be the totality of the records. In other words, the RTC would not and should not rely only on the certification of the fiscal that he found probable cause. Yung certification, nandun yun sa face of the information that he found probable cause. Because that finding, that certification of the fiscal is only with respect to his finding of probable cause to indict. With respect only to his finding of probable cause to charge the accused with an offense before the court. So sabi ng court, sabi ng Supreme Court, you do not rely simply on the certification. You are under obligation to read the entire records for purposes of determining probable cause. If after determining probable cause, based on the entire records, inclusive of the record before the prosecutor's office, but which, however, do not form part and should not be considered to form part of the record of the court, then issue a warrant of arrest. If, however, you find no probable cause, ito exception lang ito, please take note. This will not justify the motion for determination of probable cause to indict. This will not, yung puso-puso ngayon, I told you kanina, no? Yung motion for determination of probable cause, this will not justify, kasi exception ito. Remember the case of Aliato versus Jokno? 1995 case? Aliato versus Jokno, doon, the judge relied only on the certification of the fiscal found in the information that there is probable cause. That a preliminary investigation has been conducted and there's reasonable ground to believe that the defendant or the accused has been given an opportunity to submit controverting evidence, and the court and the fiscal finds probable cause to believe that the crime has been committed and that the accused is probably guilty thereof. Yun ang certification eh. The judge now, the RTC judge, relied simply on the certification. Issued a warrant of arrest based on that. Remember, nag-determine siya ang probable cause to issue a warrant of arrest. Simply on the basis of the certification, the RTC judge issued a warrant of arrest. And immediately, the accused were arrested. Sila Aliado. Okay, mga lawyers yan, they know what they're talking about. The lawyers were the ones arrested, so they brought it up on what? Habeas corpus. First certiorari and then habeas corpus after the Supreme Court. Sabi ng Supreme Court, the judge read the entire records and not simply relied on the certification of the fiscal, which found probable cause only to indict. Sabi ng Supreme Court, had the judge relied, he would have found out that there was totally no basis for determination of probable cause, even for purposes of indictment. Na-set aside yung warrant of arrest. And the judge was reprimanded. Because of that. Because sabi nga, ang obligation ka, not only to rely on the certification, but that is an exceptional case. Now, if the court, sabi nga yan, for purposes of issuance of a warrant of arrest, once the information is filed in court, if the court has any doubt, then and only then can the court demand that the prosecution submit additional evidence to aid it in the determination of probable cause to issue a warrant of arrest. But when it comes to the FTC, yung issuance of a warrant of arrest, the FTC would have to question to determine probable cause. Based on that, it is determined at FTC if there is a need to take the accused in immediate custody in order not to frustrate the ends of justice. Follow nyo? So these are two distinct concepts. Determination of probable cause to indict is an executive function performed now only by the fiscal. Determination of probable cause is for purposes of issuance of a warrant of arrest is a judicial function. And for the court to issue a warrant of arrest, kailangan he would have to read the entire records. RTC. Okay. Kasi diba, yung resolution subject of the investigating judge, wala na yan, no? Because the MTC judges are no longer allowed to conduct preliminary investigation. Okay. Let me just go to arrest. So arrest is Article 113. Arrest is Article 113. Okay. It is only, generally, it is only by virtue of a warrant of arrest that an arrest is lawful. You can only effect a lawful warrant arrest under any of the circumstances provided for in Section 5 of Rule 113. So the warrant of arrest is to arrest, indistinguishing your from a search warrant. A warrant of arrest has a lifetime. What is the lifetime of a warrant of arrest? As distinguished from the lifetime of a search warrant. Tingnan nyo very express under the rules. A search warrant has a lifetime of only 10 days from date of its issuance. A warrant of arrest, under the rules, sabi dito, 10 days to execute, upon issuance of the warrant of arrest, binigay sa police, 10 days to execute the warrant, 10 days to effect the service of the warrant of arrest, and 10 days to make a warrant of arrest. No. The 20-day period here is not the lifetime of a warrant of arrest. For as long as the warrant of arrest has not been served, that subsists. For as long as the warrant of arrest has not been served, that effectively subsists. Remember yung recent cases, yung mga rebellion? These are subjudice. I'm just telling you lifetime. Di ba nagkaroon ng argument with respect to that, the lifetime, the warrant of arrest? According to the police, even if the case is 1985, but the warrant of arrest has not been served. Therefore, the warrant of arrest subsists. Under the rules. Okay. Sabi naman nila, why did you not serve it? This person has been always there in Congress. Kita-kita niyo namin sa dyaryo. Kita-kita niyo namin, you can serve it anytime. Why didn't you serve it? Di ba? Okay, that's the question. But the point is, I'm just telling you, the lifetime of a warrant of arrest, it subsists for as long as it has not been served. Pero yung search warrant, very clear. A search warrant has a lifetime of only 10 days, record from the date of its issuance. Thereafter, it is void. Thereafter, it is void. Okay, now, another point of distinction. A warrant of arrest can be served on any day, at any time of day and night. Very clear naman yan, under Section 6 of Rule 113, a warrant of arrest may be served, an arrest may be made on any day, at any time of day and night. Tingnan niyo ang search warrant. The rule is, a search warrant can only be served at daytime. That is the general rule. A search warrant can only be served at daytime. It can be served at nighttime for as long as the authority to serve it at nighttime is indicated on the face of the search warrant itself. And there must be good reasons for the authority to be indicated on the face of the search warrant itself. For example, dala-dala ng tao. It can be kept anytime, or it's actually there. It's only there that the items sought to be searched and seized are there only at nighttime. So it will defeat the purpose of the search warrant if you do not give us authority to serve it at nighttime. But generally, take note, a search warrant can be served only at daytime. It cannot be served at nighttime. It can only be served at nighttime for good reasons to be determined by the judge, and the authority to serve the search warrant at nighttime must be expressly indicated on the face of the search warrant. Pero ang warrant of arrest, an arrest can be effected on any day, at any time of day and night. Is it clear? Now, let me just point out to you yung bail. I will stop after this, Okay. Bail, tingnan niyo, please remember the concept. Bail is the security given for the release of a person in the custody of the law. Please, i-memorize niyan. Kailangan ba i-memorize niyan? Kailangan. Bail is the security given for the release of a person in the custody of the law. Okay. Somebody committed a crime. Somebody committed a crime. After the commission of the crime, he fled from the crime scene. He disappeared. He did a Houdini. He disappeared from the crime scene. He ran away from the crime scene. Nagkaroon ng proseso. He was identified. But he cannot be found, but he was identified. There were witnesses. Okay? A complaint was filed against him before the prosecutor's office. The prosecutor's office finds probable cause to indict. And the information is filed in court. Upon the filing of the information in court, the court now makes a determination and finds probable cause to issue a warrant of arrest. A warrant of arrest has been issued. That fellow now, who committed the crime, learns of the filing of the information in court against him. He has been in hiding since the commission of the crime. He learns of the filing of the information against him in court, and he subsequently learns that the warrant of arrest has already been issued against him. He tells his kumpare, pare, meron ng information against me. Pare, meron ng warrant of arrest against me. Pwede ba? Natatakot ako. If they find me, they will arrest me. Pwede ba? Mag-post ka ng bail. So I find out what the information was filed before, and then post bail for me. The kumpare naman, goes to that court, files the court, post bail. Question, can the application for bail be given due course? There's already a warrant of arrest that was issued. Definitely not. Why? Bail is the security given for the release of a person in the custody of the law. He's not yet in custody. So premature. He's not yet in custody. And therefore, he first has to submit to the custody of the court before he can post bail. Mga petition for bail, pag wala yung tao, deny. Application for bail, deny. Why? Kasi it is premature for cause of the bail. It is the security given for the release of a person in the custody of the law. So for the release, paano ka nililist? Naka-release na ka, no? Diba? For the release of a person in the custody of the law. Okay, now, take note conditions of the bail. Let me call attention to this. Kasi may 2004 admin ruling ng Supreme Court, admin order ng Supreme Court, administrative circular ng Supreme Court. Dito sa Section 2, paragraph A, the undertaking in the bail shall be effective upon proven, and unless cancelled, shall remain in all stages in force at all stages of the case until promulgation of the judgment of the RTC, irrespective of whether the case was originally filed in or appealed to in. Okay. No problem if it's cash bail, no? Hindi mo na i-release. Okay. Now, tingnan niya, but if it is surety bond, okay. Sabi, before the revision of the rules, before ito, if you want an extension of your bail, mag-expire na, you want an extension, you want a renewal, you first have to ask the permission of the bonding company. Because they will be the one making the undertaking Okay, what if you jump in? They will be burdened with looking for you and bring you back to the jurisdiction of the court. Correct? Okay, so that is under the rules, it shall remain in force in all stages of the case until promulgation of the judgment of the RTC. Judgment of the RTC, which meant, irrespective of whether the case was originally filed with the RTC or it was appealed to it. So yung undertaking for the provisional liberty, undertaking under the bail for the provisional liberty of the accused is only up to the promulgation of judgment of the RTC. Diba? Very clear. Now, Supreme Court circular dated 2004, I forgot the circular number. Nakalagay na doon, ang bagong undertaking of the bonding company, the undertaking to, the bail will remain in all stages of the case until after the final resolution of the case. So you don't need to renew anymore. So because the undertaking there is until final resolution. Aside to bring, hindi, wait lang, papasok mo. Aside to, I'll cause to be delivered. A copy of the certificate, bago yan amended undertaking. It shall be valid in all stages until final resolution. So if the case goes all the way up to the Supreme Court, pwede pa rin yung bail mo under the new circular sa 2004. Admin circular of the Supreme Court. Hindi na to. Next point. Ito, please lumalabas na parang ito, no? Paragraph C. The failure of the accused to appear at the trial without justification, despite due notice, should be deemed a waiver of his right to be present. In such case, the trial may proceed in absentia. Okay, trial in absentia. So what would be the requirements for purposes of trial in absentia? Sabi dito, the failure of the accused to appear at the trial, meaning that, failure of the accused to appear at the trial, meaning that, na-arraign na siya, correct? He has already been arraigned, which is arraignment, pre-trial, and trial. So, sabi dito, the failure of the accused to appear without any justifiable reason at the trial, meaning na-arraign na siya, nag-jump bail siya. If he has to appear, nag-jump bail siya. Remember, one of the conditions is he would appear. or if he does not appear, ang condition that the case can, against him can proceed in absentia. So, if he fails to appear without valid reason at the trial, na-array na siya, court can proceed trial in absentia. Okay, now what if the accused posts bail? He's detained, he posts bail. He's notified of the scheduled date of the arraignment and pre-trial conference. On the date of the arraignment and pre-trial conference, he's arraigned. He's arraigned. Okay. After his arraignment, the case is set, in pre-trial, the case is set for trial. On the date scheduled for trial, he disappears. He jumps bail. Can the court proceed in absentia? Yes! Namin na siya. What if the accused is detained? He posts bail. He's notified. Bail naman yung offense. He's notified of the scheduled date of his arraignment. On the date scheduled for his arraignment, despite notice, he jumps bail. He does not appear. Question: can the court try the case in absentia? Remember, nag-post na siya ng bail. Effectively, the court already acquired jurisdiction over his person. Okay. After having posted bail, the case is set for arraignment. On the date scheduled for the arraignment, he does not appear. Without any justifiable reason, justifiable cause, he fails to appear. Question: can the court proceed in absentia? Can the court proceed in absentia? No! Kasi wala kang arraignment, di ba? Nag-post lang siya ng bail. The court, by virtue of the post of the bail, the court effectively acquired jurisdiction over his person. But he has not yet been arraigned. So, if he does not appear, the bail will be confiscated. Eh di wala ng reason. And the court loses jurisdiction again over his person. Na-confiscate yung bail and award the reservation against him. So wala ng jurisdiction ng court over his person. So what happens to the case? If he does not appear, and the court cannot proceed in absentia because he has not yet been arraigned and the bail has been confiscated, can the court dismiss the case? Nabilis ba? Can the court, kasi, di ba nag-post na siya ng bail? Para ng children, nag-post na siya ng bail. Considered naka-acquire jurisdiction over his person. On the date scheduled for the arraignment, he does not appear. So, warrant of arrest, confiscated. What is the purpose for issuance of the warrant of arrest? Kasi wala na nga jurisdiction eh. Na-confiscate yung bail in favor of the government. So, for a court to reacquire jurisdiction over his person, warrant of arrest, correct? Now, so wala jurisdiction of court over his person. The court definitely cannot proceed in absentia. Okay. Next question. Can the court, what happens to the case? Can the court dismiss the case? Can the court dismiss it? No! The court cannot dismiss the case. Why? Because the court has jurisdiction over the offense. Di ba na-file na information? So the court has jurisdiction over the offense. So what happens? Wala naman jurisdiction over the person accused. Then, the case will simply be sent to the archives without prejudice to its reinstatement upon the apprehension of the accused. How is the accused going to be apprehended? By virtue of the warrant of arrest that was issued. Diba? Di ba na pag ganun-ganun? Tatandaan nyo, Ganun. Very important yan. Magulo sila sa baray. Okay. Now, another point. Yes, lumalabas din sa bara, when is bail a matter of right? When is bail a matter of discretion? When is bail neither a matter of right nor a matter of discretion? Okay. When is bail a matter of right? Before and after conviction by the MTC. Number 2, matter of right before conviction by the RTC for an offense which is not penalized by death, imprisonment perpetua, or life imprisonment. When is bail a matter of discretion? Or whose discretion? Discretion of the court na to, Matter of right on the part of the accused. Matter of discretion on the part of the court. When is it a matter of discretion? After conviction by the RTC for an offense which is not penalized with death, imprisonment perpetua, or life imprisonment. Likewise, bail may be a matter of discretion if the imposable penalty is 6 years or more under any of the circumstances. Matter of another one, if he is a recidivist, a quasi-recidivist, or habitual delinquent, or has committed the crime aggravated with the circumstances of reiteration in 4 forms of repetition. Remember, in your criminal law, 4 forms of repetition: recidivism, quasi-recidivism, habitual delinquency, and habituality or reiteration. Alam niyo na yan, di ba? Will I describe? No. Okay. So, if the bail may be refused, if he jumps bail, okay, he has previously escaped confinement, etc. So, bail is a matter of discretion. Now, bail is neither a matter of right nor a matter of discretion if the offense is penalized with death, reclusion perpetua, or life imprisonment. Neither a matter of right nor a matter of discretion. Why? Because in that case, you have to file a petition for bail. And bail will be granted or will be denied depending on the weight of the evidence. Whether the evidence of guilt is strong or not. If the evidence of guilt is strong, then bail will be denied. If the evidence of guilt is not strong, bail will be granted. But the burden of proof in bail application hearings is on the prosecution to prove that the evidence of guilt is strong, and therefore the petition for bail would have to be denied. The petition for bail would have to be denied. Okay, now, burden of proof. Please take note, in petition for bail or application, the application for bail would have to be always set for hearing. Would always be set for, because may burden of prosecution The prosecution has the burden of proving that the evidence of guilt is strong, and therefore bail should not be granted. It is not enough, take note, according to the Supreme Court, that the prosecution simply manifests that it interposes no objection to the accused's application for bail. No. I'm fully aware of this because it happened sa totoong buhay, no? One of my friends, judges, was fined 10,000 because he allowed the prosecution. He did not anymore let the prosecution submit evidence on the bail application for hearing. Sabi niya, anyway, walang objection ng prosecution. I granted bail. Sabi sa paper, no. Even if the prosecution interposes no objection to the application for bail, kailangan pa rin iset mo yan for hearing. And because you have the burden of proving, the prosecution has the burden of proving that the evidence of guilt is strong. Okay, now, your forms of bail, you have what? Cash, surety bond, property bond, recognizance is even a form of bail. Okay, now, yung forfeiture, iba yung sa forfeiture and confiscation, iba yan sa cancellation. Of course, you know that, no? Forfeiture of the bail, confiscation of the bail, if the accused fails to appear. If the accused jumps bail for no valid reason. Cancellation, merong regular cancellation, merong automatic cancellation. If it's automatic cancellation, upon acquittal, automatic meaning you don't need to file a motion. Automatic cancellation of bail, upon acquittal of the accused, dismissal of the case, or execution of judgment. Kasi execution of judgment, you don't need provisional liberty for bail. A bail for provisional liberty, ini-execute na sineserve na yung judgment. So don't need to be released. You have no right to be released anymore. So, automatic cancellation of bail, acquittal of the accused, natural. Okay, acquittal, dismissal of the case, or execution of judgment. Now, if it's ordinary cancellation, upon what? Proof of death, or proof of death of the proof of death of the surrender of the accused, or proof of death of the accused. Cancellation of bail. Now, please take note of this, Importante ito Where do you post bail? Where do you post bail? Okay. You post bail either in the court of the place where your case is pending, or in the court of the place where you are detained. If you are detained in a place other than the place where your case is pending, you may post bail there. And the bail will now be transmitted to the court where your case is pending. So, dalawa yan, no? Where do you post bail? You post bail in the court where your case is pending, or you post bail in any of the appropriate court of the place where you are detained. If you are detained in a place other than the place where your case is pending. Okay, now, what if your case is pending, in Manila? You were arrested in Quezon City. So, you are arrested in Quezon City. You can post bail in either Manila or Quezon City. Correct? The problem is, there is no judge to approve your bail. Either in Manila where your case is pending, walang duty judge. At the time you would want to post bail for a bailable offense. At the time you would want to post bail, either in Manila, where your case is pending, or in Quezon City, where you have been arrested and you're allowed to post bail. Walang duty judge. There is a single duty judge in Makati, for example. Okay, there's a duty judge in Makati. Question: can you post bail in Makati? Can you post bail in Makati? No! Very clear. You post bail in the court of the place where your case is pending. Or where you are arrested, where you are detained. I don't know. Where you are detained. Okay, now, what if you are arrested in one place, but for a bailable offense, but you are not, you are arrested in one place, but no information has as yet been filed in court against you. You are arrested for an offense which is bailable, but no information has as yet been filed in court against you. Question: can you post bail? Yes, because it's bailable. Next question. Where do you post bail? Where can you post bail when no information has yet been filed in court against you? Yung last paragraph. Last paragraph of Section 17, Rule 114. Any person in custody who is not yet charged in court may apply for bail with any court in the province, city, or municipality where he is held. In other words, hindi na pwedeng i-reject ng court yan. Wala kang information, how can I prove bail? Because you are the court where he is detained. And he is detained for a bailable offense. Therefore, you can give due course to the application for bail, even if there is no information as yet filed in court. Okay, now, reduction of bail. This is very important. Let me call your attention to this. Section 24. Section 24 of Rule 114. Ay, sandali lang. Ito pala. Yung where do you file bail? I'm sorry. Dito sa paragraph B, kasi this is in relation to yung the LTC judge can no longer conduct PI. If you read paragraph B of Section 17, Rule 114, where the grant of bail is a matter of discretion, or the accused seeks to be released on recognizance, the application may only be filed in the court where the case is pending, where the grant of bail is a matter of discretion, or the accused seeks to be released on recognizance, the application for bail may only be filed in the court where the case is pending, whether on preliminary investigation, trial, or appeal. Please, tanggalin nyo na yung on preliminary investigation. That is one of the amendments. Because the LTC judges can no longer conduct preliminary investigation. So, paki-remove na yan, yung where the case is pending, whether on preliminary investigation, trial, or appeal. Hindi na. Wala na yung preliminary investigation because the court are no longer allowed to conduct preliminary investigation. Paano? Okay. As of October 3, 2005. Okay. Now, let me go now to Section 24, which is very important. Please take note of this, I bet you, hindi nyo naisip to. No bail after final judgment. Okay, no bail after final judgment. No bail shall be allowed after a judgment of conviction has become final. No bail shall be allowed after a judgment of conviction has become final. If before such finality the accused applies for probation, he may be allowed temporary liberty under his bail. No bail may be allowed once a judgment of conviction has become final. Kasi judgment of acquittal, immediately final yan. Okay, now, once a judgment of conviction has become final, no bail shall be allowed kasi serve din sa sentence. Next question. When does a judgment of conviction in a criminal case become final? Diba apat? The judgment of conviction in a criminal case becomes final under the following circumstances. One, after the expiration of the period to appeal, which is 15 days, reckoned from promulgation or notice of judgment. No appeal having been taken from the judgment becomes final. Number two, if there has been an express waiver of the right to appeal, judgment becomes final. Number three, if there has been a total or partial service of sentence, judgment becomes final. In number four, ito na, number four, parang loto. Number four, upon the filing, namataya ako dyan, upon the filing of an application for probation. Crucial ito, fourth, upon the filing of an application for probation, judgment under the rules is considered as final. Di ba you learn in your criminal law 1? Once a judgment of conviction is rendered within a period of 15 days, the accused is given the opportunity to file appropriate pleading, either to file a notice of appeal or to file an application for probation. The application, the notice, these are two remedies available to the accused who has already been convicted. Within a period of 15 days from date of promulgation or notice of judgment, he may file either a notice of appeal or a petition for probation. He cannot avail of both, di ba? Under PD 968 as amended, he cannot avail of both. He cannot avail of them exclusively or extensively. Once you avail of one, precluded ka na from availing of the other. Which means that, di ba? Once you file a notice of appeal, that means you are still questioning the propriety of the judgment of conviction rendered against you. Kasi your appeal to correct error of judgment. Okay, so you file a notice of appeal, judgment does not become final. But once you file a petition for probation, why is it that it becomes final? Because once you file a petition for probation, you are no longer questioning the propriety of the judgment of conviction rendered against you. You want already to avail of the benefits of PD 968 as amended, the probation law. Why? Because you want to be rehabilitated in order for you to go back to the mainstream of society. Di ba? Rehabilitation na. Either or talaga. Hindi mo pwedeng simultaneously or exclusively. Learn this in your grade law. That is why, once you nakalagay dito sa rules, once you apply, the mere fact that you apply for probation, judgment becomes final. Judgment already becomes final. Hindi ka na question in judgment. You are willing to accept the judgment already. Remember, filing pa lang of an application probation renders the judgment final. Hindi the granting of the application for probation. It is the mere filing of an application for probation that renders the judgment final. Ito, Section 7 of Rule 120. Section 7 of Rule 120, or when the convict has applied for probation. Application pa lang, it renders the judgment final. Okay na tayo dyan, when does the judgment of conviction become final? So, okay na tayo dyan. Now, so once you apply for probation, judgment becomes final. The law says, once judgment has become final, you cannot be awarded bail. You cannot be granted bail. No bail shall be allowed after judgment of conviction has become final. One of the instances when a judgment of conviction becomes final is when you apply for probation. Diba? Okay, that's the fourth. Okay. You apply for probation. But why is it that once you apply for probation, bail is allowed? Diba bail is allowed? If you apply for probation, under PD 96 as amended, either you post bail, if you cannot post bail, you can ask for recognizance. and you'll be released from recognizance to a responsible member of the community. That's provided for in PD 968. But the rule says, once you file an application, once the judgment becomes final, bail is no longer allowed. And the same rule says, and a different rule says, rules of criminal procedure, once you file an application for probation, judgment becomes final. O, hindi ba para inconsistent? Sige na, kumain na kayo. So, tingnan niyo kasi ito. If before such finality, the accused applies for probation, he may be allowed temporary liberty under his bail. Tingnan niyo. If before such finality, meaning, ang kinocontemplate na finality dito, yung regular finality, that is, you don't file any notice of appeal within the 15-day period record from promulgation of judgment. No appeal is taken. So judgment becomes final. Yan yung sinasabi niyan. That is why sinabi nila, if before such finality, meaning, if before the lapse of the 15-day period within which to file a notice of appeal, nag-apply ka for probation, you may be allowed temporary liberty. So again, how do you reconcile that? But sabi ng rules, but you can file an application for probation. Judgment is final, and therefore under the same rule, pag judgment is final, you're no longer allowed bail. Diba? Ang ginugulo ko ba kayo? Nagugulo na rin ako. Okay, so diba na? So once you no bail after, so how do we resolve the inconsistency? If you file an application for probation, under the rules, judgment becomes final. Okay? If you file an application for probation, tatanggalin ka na sa operation of the rules of criminal procedure. Pasok ka na sa PD 98. Because you're invoking already a different law. Diba? Under PD 96, as I mentioned, you are allowed provisional liberty. Either on bail or on recognizance to a responsible member of the community. Gets niyo? Kaya nga, exception eh. Sabi niya, before such finality, yung sinasabi nilang finality dyan, yung 15-day period that you don't appeal. Just na becomes final. Eh kaso naman, i-relate mo yan in another provision of the rules, di ba? Once you file an application, final na yan. Tapos bumalik ka dito, pag final na, no bail. Eh bakit pag probation? You're allowed bail. Di ba? And therefore, pag nag-file an application for probation, bail is allowed. Even if judgment has already come final. Because, once you file an application for probation, under the rule, final na judgment. But once you file an application for probation, aalisin ka na dito, no? You now fall under the provisions of 963. Because it's a special law. Where you are allowed bail. Either on bail or a provisional liberty, either on bail or in recognizance to a responsible member of the community. Gets niyo? Okay, now, a new provision under Section 26 of Rule 114, bail is not a bar to objections on illegal arrest. Bail is not a bar to objections on illegal arrest, lock-off, or irregularity, lock-off or irregular preliminary investigation. This is a new provision actually, because you know, before the revision of the rules, if the accused posts bail for an offense, which is bailable, pag nag-post bail siya, and then is scheduled for arraignment, the counsel moves for deferment of the arraignment because they're asking for a re-investigation or a preliminary investigation. That is usually denied once the court finds out that he has already posted bail. That will be denied once it is shown in the records and the court finds out that he has already... Ang first question dyan nakapiyasa ka na? Sabi niya, opo. Okay, denied. Pero ngayon hindi na. Even if you have any objections to the illegality of the arrest, or lack of, or irregular preliminary investigation. Wala kang preliminary investigation, or irregularity is committed in the course of the preliminary investigation, okay, even if you posted bail, pwede ka pa rin mag-question. Very clear. But, you have to raise the objection before arraignment. Before entering the plea. Is it clear? Okay, can I stop there? I'll finish tomorrow.
Ano ba yung pinapapasok? Ano na charge?